This is Professor Cristina Poncibò from the University of Torino. Good evening. We are truly honored to receive the 2025 Antitrust Writing Award in the digital category for our article Antitrust Mega Fines in Digital Markets and Their Impact on Compliance, an overview of EU-US approaches.
Hi everyone, it's Umberto Nizza from Torino. Although we cannot be with you in person tonight, we want to express our sincere gratitude to the Antitrust Writing Award Committee for this incredible recognition. Given the rigorous selection process and the high quality of the contributions in this category, it's a privilege and honor to receive this award.
We also wish to extend our heartfelt thanks to the institutions that have supported this research. The University of Torino has played a crucial role in fostering our work. Likewise, the Transatlantic Technology Law Forum at Stanford University has provided an outstanding space for intellectual exchange on competition law and digital markets. Finally, we are grateful to the broader academic and professional antitrust community for continuously pushing the debate forward on these complex issues.
Regarding what we do in our paper, we essentially examine the role of mega fines in digital markets, comparing antitrust enforcement approaches in the European Union and United States. In recent years, competition authorities have imposed record-breaking fines on major digital platforms, but how effective are in ensuring compliance? We identify three takeaways from our research.
First, in the European Union, competition authorities have relied extensively on large fines to enforce antitrust rules. However, the deterrent effect is not always straightforward. On the one hand, fines demonstrate a firm regulatory stance. On the other, when imposed without behavioral or structural remedies, their actual impact on market prices remains uncertain. Some firms may simply factor fines into their cost structures, particularly when the financial penalties do not fundamentally alter the business incentives or market power dynamics.
Second, the United States has traditionally followed a different path. While US authorities have historically favored litigation and settlement over monetary sanction, recent cases have indicated a shift. There is now an increasing willingness to impose substantial fines. However, even as the US moves toward financial penalties, regulators remain focused on conduct-based remedies, such as commitments to change business practices, rather than imposing purely financial sanctions.
Third, and most importantly, our research suggests that fines alone are not enough to ensure compliance in digital markets. While they play an important role in demonstrating regulatory intent and deterring future violations, their effectiveness depends on their integration into a broader enforcement strategy. This means that competition authorities must go beyond financial penalties to include ongoing monitoring, behavioral restrictions, and, when necessary, structural remedies. The challenge in digital markets is that dominant firms often operate in complex, multi-sided ecosystems, where a fine may address one aspect of the anti-competitive conduct, but leave the broader market dynamics unchanged.
Ultimately, we hope our work contributes to the ongoing discussion on how to build more effective antitrust enforcement mechanism for digital markets. The dominance of major tech platforms poses unique regulatory challenges, requiring authorities to adopt a more dynamic and adaptive approach, one that balances financial sanctions with proactive oversight and structural intervention when needed.
Once again, we are deeply grateful for this award and for the opportunity to share our research with a distinguished audience. We would like to thank the award committee for this recognition, as well as the institutions and the colleagues who have supported our work. Although we cannot be there in person, we are honored to be part of this incredible global antitrust community.